Live.
Good afternoon. Welcome to Seat at the Sitting SCOTUS preview for November 2024. I'm Nate Kaczmarek, Vice President and Director of the Practice Groups for the Federalist Society. Happy Halloween to all. We are delighted that our great moderator and expert panel could take time away from their pumpkin carvings and costume preparations and help us today to figure out what tricks or treats we might expect at upcoming oral arguments before the Supreme Court. But before we get to our panel, I'd like to note that our practice groups are busy preparing the largest national lawyers convention in our organization's history next month, November 14th through the 16th here in Washington, D.C. This year's theme is Group Identity and the Law. We have now sold out our annual Scalia dinner, and even with a move to a larger facility, we have sold out the conference for Thursday and are closing in on selling out Friday and Saturday. So if you don't have a ticket and you'd like to learn more or attend, please visit our website, fedsoc.org. Turning now to our discussion today, for the next 90 minutes or less, we're looking forward to a great preview of the SCOTUS docket for the upcoming month. As always, we start with the usual disclaimer. All opinions expressed during this program are those of the speakers and not the Federalist Society. For our moderator this afternoon, we are delighted to welcome Sarah Childs. Sarah, how are you?
Hi, Nate. I'm great. Happy to be here.
I'm glad you're here. Other than our exciting program this afternoon, do you have any Halloween plans?
Maybe thinking about getting some trick-or-treating in myself. I do love candy, so.
That's good. I told my kids this morning that I was going they asked what I was going to be dressed as. I said a scary lawyer. They're too young for rude retorts about that.
That's what we are
anyway,
already.
It's good to have you with us. Looking forward to the panel and very excited to get started. So Sarah is an attorney in the New York City office of Jackson Lewis. She represents employers in workplace law matters arising under state and federal discrimination statutes. Prior to Jackson Lewis, she clerked on the United States Court of Appeals for the 8th Circuit, the United States District Court for the Eastern District of North Carolina. She has previously worked at other law firms in New York and DC and is a former attorney advisor with the U.S. Department of Education's Office of the General Counsel. For full bios for Sarah and all of our panelists today, you can visit our website to review them there. But in the interest of time, we're cutting them short to get straight to the discussion. Today's panel will cover the upcoming cases, and then we'll go to audience Q&A. So please think about the questions you'd like to pose for our panel in advance. We are streaming on many of the Federal Society's platforms this afternoon, but if you've joined us by Zoom, your questions can be submitted with the Q&A function at the bottom of your screen. We will endeavor to answer as many of the audience questions as we can. With that, I think we're ready to start. So Sarah, please take it away.
Great. Thanks so much, Nate. I'm going to start by providing a brief overview of the schedule this afternoon. So first, we will hear from our distinguished panelists who will each discuss one or two cases the Supreme Court is slated to hear this November. I will then quickly touch on the remaining cases in the November sitting before we turn to Q&A. During Q&A, the panelists will have the opportunity to ask questions of each other, and we will also take questions from the audience. So please put your questions in the Q&A bar at the bottom of your screen at any time. And please indicate the panelist that your question is directed to. We will try to get through as many of them as possible. With that, I will provide a very brief bio on each speaker so we can jump right into the cases. But please keep in mind that a more comprehensive background, as Nate said, on each panelist's credentials is available online. So I do encourage you to check those out because these intros really do not do them justice. So we will first hear from Karen Harned, president at Harned Strategies, LLC, and former executive director of the National Federation of Independent Business Small Business Legal Center. Up next will be Tyler Badgley, senior counsel at the U.S. Chamber Litigation Center. We will then hear from Colin White, of counsel to Kellogg Hansen. And finally, closing us out will be Bob Peck, the founder and president of the Center for Constitutional Litigation. Karen, the floor is yours.
Great. Thanks for having me, Sarah, and thanks for those that are joining us today. So I'm here to talk about a case in Wisconsin, Bell versus Keith, and that's a case concerning a favorite of a lot of Supreme Court practitioners, the False Claims Act. In this case, we're discussing, or the case is considering, the court's considering whether the False Claims Act applies when private actors pay private funds to a private entity that administers a federal agency's regulatory program. And the False Claims Act, among other things, allows people like Mr. Heath, who is in this case as a relator, to enforce the act under on behalf of all of us, on behalf of public citizens. And enforcing the act means trying to like root out abuse and fraudulent claims and fraudulent payments made or claimed by businesses primarily in their dealings with the federal government, typically as federal contractors or in some other contractual relationship with them. So this particular case concerns the Federal Communications Commission, which their mission is to help ensure that Americans have access to telecommunications services at reasonable prices, among other things. And pursuant to the Telecommunications Act of '96, the FCC established a set of universal service programs that are financed by the Universal Service Fund. The statute requires carriers like Wisconsin Bell to contribute to that fund pursuant to rules that the commission establishes. And a private nonprofit organization, Universal Service Administrative Company, administers that fund. No government monies go directly into the program, but or I guess that may be a bit of a debate, but for the most part, let's say that's the case by a large part. But FCC's regulations authorize FCC, DOJ, and the Treasury to go after carriers that fail to pay their contributions and collect penalties and interest on delinquent payments into the U.S. Universal Service Funds. So at issue in this case is one of the many programs that fund administers. It's called the Schools and Libraries Universal Service Support Program, which is shorthanded for Education Rate or E-Rate program. So that's how I'll refer to it moving forward. And that subsidizes internet access and other services for schools and libraries. Carriers like Wisconsin Bell are required to charge libraries and schools the quote unquote lowest corresponding price for telecommunications services. So that means they need to measure the lowest price for similarly situated non-residential customers for similar services and charge that rate. When a school or library receives services under the E-rate program, then they're going to pay the price and submit a request for reimbursement from the fund. Or they're going to pay a discounted price. They're going to pay the full price and request reimbursement, or they're going to pay the discounted price. And the service provider itself is going to submit a request to the Universal Service Administrative Company for the rest. So as I mentioned, the False Claims Act is enforced a lot by relators like Todd Heath. He's empowered to bring lawsuits against entities they believe are defrauding the government in some way. And in this case, relator Heath alleged that Wisconsin Bell charged schools and libraries more than the lowest corresponding price, making all of its reimbursement requests to the Universal Service Fund program, quote unquote, false claims under the False Claims Act because they carried purported certifications of compliance with the program requirements. But among other things, Wisconsin Bell is arguing that the E-rate reimbursement requests are not False Claims Act claims because the government doesn't provide any of the money requested, and the program's administrator is a private nonprofit corporation, and they are not a government agent. So this court case comes to us from the Seventh Circuit. And on summary, it started in the U.S. District for the Court of Eastern District of Wisconsin, which granted summary judgment for Wisconsin Bell, finding that he had failed to demonstrate falsity or scienter, which are critical elements needed to prove a False Claim Act violation. Heath appealed, and the Seventh Circuit reversed as a matter of law. Um, uh, and it said that reimbursement requests under the E-rate program did count as actionable items under the False Claims Act. They gave 3 alternative bases for these conclusions. They acknowledged that the USF is primarily funded by telecommunications companies, but it also receives monies from the U.S. Treasury, which collects delinquent debts to the fund, penalties and interest, and civil settlement and criminal restitution payments. But just for perspective, what the government, any government expenditures for this fund are dwarf what the fund's annual budget are. So it's maybe it's $100 million, which I know is a lot for all of us, but this is a $5 to $8 billion a year program. So that's an important distinction. And since a claim under the FCA applies, if the government provides, the court says, any portion of the funds, they said that the federal money was sufficient to bring this E-rate program under the False Claims Act jurisdiction. It also found, secondly, that the Universal Services Administrative Company, the non-governmental entity that administers the program, was an agent of the United States because it was created by the FCC. And finally, the Seventh Circuit found that the degree of government involvement in the E-rate program, from Congress ordering the commission to collect the fees, to fund it, to FCC setting the fee amounts, to the FCC establishing the Universal Service Administrative Company to manage the fund, all was sufficient to say that the U.S. quote unquote provided the money in the E-rate program, again meeting the definition of a claim under the False Claims Act. In its decision, the Seventh Circuit did go against a Fifth Circuit decision in U.S. XREL Shoup versus Cisco Systems. And in that case, in Shoup, the Fifth Circuit had found that the False Claims Act did not apply to the E-rate program, the one we're talking about today, finding that the Universal Service Administrative Company was explicitly a private corporation owned by an industry trade group, even if it was created by the actions of Congress, the FCC, and that the money that the Universal Service Fund, money in that fund was indeed provided by these telecommunication providers like Wisconsin Bell, excuse me, because of a mandatory contribution scheme that FCC and Congress established. So therefore, it was not a tax. And so, again, the relator would not be advocating on the interests of taxpayers, which is really what the False Claims Act envisions. So the Fifth Circuit found, quote, there were no federal funds involved in the program, that the Universal Service Administrative Company was not itself a government entity, and that the government did not provide any portion of the E-rate funds. The court said, although the United States, this is the Fifth Circuit, although the United States may have a regulatory interest in the E-rate program, it does not have a financial stake in the fraudulent losses. And that's really important. And they go on to say that recovery for an unqualifiable regulatory interest falls outside the scope of the False Claims Act protection, is also supported, the court noted, by damages claims in the False Claims Act, which provides a penalty of 3 times the amount of damages which the government sustains. And that's a quote, the amount of damages the government sustains. Just as an FYI or an aside, the Fifth Circuit ruled this year en banc that the funding mechanism for the Universal Service Fund is unconstitutional under the non-delegation doctrine, because it effectively delegates to the FCC and USA, the administrative company, the power to levy taxes on telecommunications carriers, which is uniquely a government prerogative. That is Consumers Research versus Federal Communications Commission. That petition is pending before the Supreme Court, and that is an interesting wrinkle, given the fact that in this instance it does appear that the word tax is used. As a former NFIB, that tax word is very triggering at these Supreme Court arguments for me. So the two principal arguments that the Wisconsin Bell attorneys are making is that the Universal Service Fund monies are coming from carriers like them. They're not coming from taxpayers like all of us. And because the government's not providing money for the program, it's beyond the False Claims Act scope. The FCC's universal service fee may provide for funds, but that is not language, and that's not the language of the False Claims Act. So they're making a textual argument, not surprisingly, nor is that the historical or legislative intent of the False Claims Act, which is meant to apply only when the government is suffering an actual loss. Second, they're arguing that the Universal Services Administrative Company is not an agent of the FCC or the federal government because it doesn't have power to bind the government in any way. The government has no role in its day-to-day affairs, which is a standard legal understanding of what it is to be an agent of the government. And therefore, they say that relationship does not exist in this case. The relator, who is joined by the Solicitor General as an amicus, is arguing that claim in the False Claims Act has broad application and provides that all the money in the USF that the government provides, they argue further that the government provides all the money in the USF by requiring its creation in the first instance and deciding how those funds are going to be collected and allocated. And so they view that qualifies as the government providing money and therefore bringing them within the sweep of the False Claims Act, that they've created the structure and they're administering it. They also argue that the FCC, DOJ, and Treasury collected approximately $100 million in civil penalties and interest from legal carriers, and thus there's actually a direct contribution there from taxpayers like you and me, and that separately makes the USF qualify for False Claims Act liability. And then with regards to whether or not the relator in this instance, has agency under the False Claims Act, they both assert, again, this is the relator and the government, that the Universal Service Administrative Company is an agent of the federal government because FCC appointed the company to administer the fund, and the company accepted that appointment, and they act directly on FCC's behalf, really effectuating their regulations and billing carrier contributions and dispersing funds according to the program's requirements. So they argue that notwithstanding the company's inability to bind the federal government, the company is nevertheless an agent of the FCC for False Claims Act purposes. I'll just say, this is, there's some interesting briefs on this. You're not going to be surprised to learn that on behalf of the relator, you've got some briefs from professors and others that are just concerned about, making sure that our dollars are spent, wisely and cracking down on fraudulent expenditures by the government. So that's really their take, if you will. On the side of Wisconsin Bell, you have an interesting brief from the Washington Legal Foundation, and that really talks about the broad application that this the court's decision in this case could have beyond just this program. They talk about, with regards to this program, actually, that it could hurt the hearing impaired that rely on relay services, because once you sweep a company or set of companies into the False Claims Act under a program, that comes with it liability, right? That's why we are here. That's going to drive up costs, and that will result, they argue, in fewer people providing these services. They also, many commentators have talked about this could, what does this mean for housing? When you think of Freddie Mac and those types of things, are they going to all be open, and their programs that they administer be open to False Claims Act liability? The chamber obviously is concerned from a business perspective, and then I have to do a shout out to my peeps at the Center for Constitutional Responsibility, because we come in with a brief saying that we think that there are real constitutional questions with regards to the False Claims Act in general by delegating this enforcement authority to private citizens like Mr. Heath to enforce them. And this is something that, if you followed a couple terms ago, the Polinsky case, which was another False Claims Act case, Justice Thomas in dissent did discuss this quite a bit, saying he just thinks there's a lot of questions here, wants to see the court take a case squarely pointing up to this at some point. And Barrett and Kavanaugh both think that is a question worth being explored, that they did not join the Thomas dissent in that case. So with that, I'm going to turn it over to my next colleague here.
Wonderful. Thank you so much for getting us off to a fantastic start, Karen. This is a good time to remind everyone to put your questions in the Q&A bar at the bottom of your screen. If your question is directed to a particular panelist, please put the panelist name in. Next, we'll hear from Tyler Badgley.
Thanks, Sarah, and thank you to the Federalist Society for having me today. I need to caveat my comments by saying that my remarks are purely in my personal capacity and do not necessarily reflect the views of the U.S. Chamber of Commerce or its members. So with that disclaimer out of the way, I'm happy to discuss two of the cases for the November sitting, and I'll start with E.M.D. Sales versus Carrera, a case concerning the appropriate burden of proof that employers must satisfy when arguing that a Fair Labor Standards Act exemption applies in defending against an employee's suit for overtime pay. So I want to start by taking a step back and discuss the statute. Then I'll dig into this specific case a bit more. So the Fair Labor Standards Act, the FLSA, was enacted in 1938, and the core pieces of the law were 1, to guarantee a minimum wage, and 2, to require overtime pay or time and a half pay for workers when they go over 40 hours a week. In general, the statute is designed to create a federal floor that applies to every employee throughout the country. But there are exemptions, and not just a couple of exemptions, but there are actually 34 classes of exempted employees identified in the statute. So for any big law associate listening and wondering what a 40-hour work week is, and if they're entitled to years of backward-looking overtime pay, one of those exemptions is actually for, quote, learned professionals. So congratulations, you're learned, and in exchange, you're not entitled to overtime pay. But that's not the only exemption. There are some that are very specific, including, for example, baseball players, switchboard operators, taxi drivers, maple syrup producers, and part-time babysitters. So if anyone needs some last-minute Halloween costume ideas, maybe look to the FLSA for some inspiration. But then there are others that are not as cut and dry, right? Those all seem very clear. We know what a maple syrup producer is. There's a multi-pronged test for learned professionals, creative professionals, executives, and, as relevant in this case, outside salespeople. And this issue comes up repeatedly and is often heavily litigated. In fact, this case was the third time in 3 years that the Chamber has filed an amicus brief supporting a cert petition on the application of one of the exemptions, and the second time the court has granted. So, bringing us back to this specific case. 3 sales representatives of E.M.D. Sales, which distributes Latin American, Caribbean, and Asian foods to grocery stores in the Washington, D.C. area, brought a suit, arguing that because they worked 60 hours per week, they were entitled to overtime pay. But the company argued that the sales reps were, quote, outside salesmen, and so were exempt from the overtime requirement. Now, everyone agrees that the sales representatives worked more than 40 hours a week. Everyone agrees that the contractual relationship is subject to a collective bargaining agreement, which, as the union shop steward testified, does not provide for overtime pay. E.M.D. sales representatives set their own hours. They don't report to office or warehouse except for meetings and deliveries, and they're compensated on a commission basis. So all that is agreed. The the district court applied a two-part test to determine whether the salesmen were outside salesmen or ordinary employees. The court asked first whether the salesmen made sales in their roles as sales representatives, and second, whether making sales was their primary duty. Now, the court applied a clear and convincing evidence standard for each inquiry and held that E.M.D did not meet that standard. The Fourth Circuit affirmed, relying on its existing precedent on the burden of proof. So this case presents a fairly narrow question. What is the company's burden of proof to establish that proposition that an exemption applies? Is it a preponderance of the evidence standard, essentially more likely than not? Or is it a clear and convincing evidence standard, essentially that the defense is highly probable, something above a preponderance, but below beyond a reasonable doubt? Now, this case arises from a 6-to-1 circuit split, with 6 circuit courts across the country holding that it is the lower preponderance of the evidence standard that is correct, and only the Fourth Circuit, which the Supreme Court has only affirmed once in the past 4 terms, saying that the higher clear and convincing evidence standard applies. Normally, this would be the portion of any Federalist Society event where we would turn to discuss the text of the statute, which the proper and faithful application thereof should dispose of this question. Unfortunately, the text is silent on the burden. No one, not the employees, the employer, the government, or the courts, have a textual argument that they rely on in advancing their position. But the Supreme Court has acknowledged clearly and repeatedly, at least 14 times by the employer's count between 1877 and 2014, that in civil cases, the default standard of proof is a preponderance of the evidence. And the Supreme Court has identified 2 exceptions to this general rule. First, if the statute's text says otherwise, which no one argues is the case here. And second, when extraordinarily important interests are at stake, which is where the employees hang their entire case. The employees argue that this dispute over overtime pay is not a mere monetary dispute, but that the broader societal purpose of the FLSA is to, quote, correct and as rapidly as practicable, eliminate unfair labor conditions, and therefore the FLSA protects the public's interest in an economy in which workers are guaranteed a fair wage. Now, I've been admonished by someone who had a case before the court recently not to make predictions about how a case will turn out today. He listened to a seat of the sitting for his case, and the panelists predicted a loss for his position in a case that turned out to be a unanimous win. So I will follow that advice here. That said, I do think even a passive observer of this Supreme Court would look at a 6-1 split, no statutory text, a clearly defined default standard of review, and an argument that essentially relies on what, quote, the policies manifest in the FLSA reveal, and could at least identify a few justices with whom the case for a clear and convincing evidence standard will not have much purchase. It seems the best fact the employees have going for them is that the FLSA rights, quote, cannot be abridged by contract or otherwise waived, because this would nullify the purposes of the statute and thwart the legislative policies it was designed to effectuate. And the employees can point to various precedents from the 40s through 80s discussing the FLSA creating a private public right and discussing the withholding of wages as an offense against the public interest. Now, the employer's principal argument is that monetary relief is all that is at issue in this case, and that should end the case. But even if the court today were to accept the employee's arguments about a quasi-public right or interest in the FLSA, does that really rise to the level of involuntary commitment, denaturalization, or the loss of parental rights, the other areas in which the Supreme Court has held that that default standard is overridden? The employer certainly answered this question with a resounding no, and the government, as well as many other amici, including the Chamber of Commerce, agree. So with that, I will now turn to discuss Facebook v. Amalgamated Bank. So my second case is also the first of 2 securities litigation cases on the docket for the November sitting, both of which come out of the Ninth Circuit. Securities litigation has always been a fertile ground for plaintiffs' lawyers. As the Second Circuit has observed, opportunistic private plaintiffs file securities fraud claims of dubious merit in order to exact large settlement recoveries. And event-driven litigation, where plaintiffs use a headline-grabbing incident that harms a company and its stock price to search for any public statements by that company that are even conceivably related to the subject matter, and then allege that the company misled its investors about it, that's a growing proportion of those suits. And to be clear, the Supreme Court has recognized that litigation under Rule 10b-5, securities fraud litigation, represents a danger of vexatiousness different in degree and in kind from that which accompanies litigation in general. And commentators have noted that the main theory in many event-driven cases these days is that the event was the materialization of an underdisclosed or downplayed risk. And this case goes right to the core of that. The question presented by this case is whether risk disclosures are false or misleading when they do not disclose that a risk has materialized in the past, even if that past event presents no known risk of ongoing or future business harm. Some of this may sound like a case that the Supreme Court heard last term concerning item 303 disclosures about known trends or uncertainties likely to have a material impact on a company's financial position, where the court held that pure omissions are not actionable for securities fraud. This case is different, so even if at first blush there seem to be some similarities, please bear with me. Here, the court will be looking at item 105, risk factor disclosures, which the SEC regs describe as a discussion of the material factors that make an investment in the registrant or offering speculative or risky. And the court is being asked whether these disclosures need to include backward-looking information in certain circumstances. Although if the Ninth Circuit's position and plaintiff's position prevails, what exactly those circumstances are will be up for debate in every case, creating more securities litigation, more risks, and increasing costs to business. So what are the facts of this case? Well, many of you are likely familiar with Facebook's Cambridge Analytica data breach back in 2015. But if not, in short, an academic gained access to Facebook's users' data through a Facebook app. Now, that use was first publicly reported in December 2015, and at the time, there was no impact on Facebook's stock price. Facebook investigated, removed the offending app, and obtained certifications that Cambridge Analytica and the professor had deleted the app and the data. Turns out, Cambridge Analytica's certification was false, and the breach was more significant than originally understood. When Cambridge Analytica's continued use of the data was reported in March 2018, there was a stock drop. But Facebook did not know of the continued use, the plaintiffs do not contend that they did, and the plaintiffs' legal theories are unrelated to that ongoing harm aspect of this breach. In fact, they specifically disclaim liability relating to the ongoing harm issues. Plaintiffs brought securities fraud claims alleging that Facebook's Item 105 risk factor statements in its 2016 10-K warned that Facebook could suffer business or reputational loss if a security breach exposed data to improper use by third parties were misleading. Specifically, Facebook's disclosure in this case reads, security breaches and improper access to or disclosure of our data or user data or other hacking and phishing attacks on our systems could harm our reputation and adversely affect our business. According to plaintiffs, this statement is misleading because it frames the future-looking risk of data misuse as merely hypothetical, despite Cambridge Analytica's actual known past misuse of Facebook user data. And instead, Facebook should have disclosed that Cambridge Analytica had used the misappropriated data, a use that had already been publicly reported and had no impact on the stock price. The Ninth Circuit held that plaintiffs adequately alleged falsity. Judge Bumate dissented, arguing that the Ninth Circuit went beyond its existing precedent in Alphabet v. Rhode Island, the subject of a prior cert petition alleging that the Ninth Circuit was already out of step with the rest of the country on Item 105, disclosure liability. So as things currently stand, there's a three-way split on this issue. The Ninth Circuit stands alone in holding that a company may be liable for the failure to disclose any past event related to a risk discussed in a forward-looking disclosure, regardless of whether harms to the company are imminent or already materializing. This is the standard that plaintiffs rely on and really requires an individualized assessment of the facts and context in each instance. At least 3 circuits have allowed some materialization of risk claims where the identified risk is imminent or already materializing. This is what the parties refer to as the, quote, virtual certainty standard. There, the question is not whether the specified triggering event has ever occurred in the past, but instead whether a previous occurrence of the triggering event is, quote, virtually certain to result in the warned of harm to the business. And the Sixth Circuit, on the other side, has rejected arguments that Item 105 risk disclosures can mislead reasonable investors about what occurred in the past altogether. This is the position Facebook is advocating. Although, I'll note, Facebook makes alternative arguments under the virtual certainty standard as well, and seems to be content with the court adopting that standard if needed. Seem to think that they can prevail under that standard if it goes back to them to the district. I suspect the justices will have a number of hypos about what would need to be disclosed and how that disclosure would need to be worded under the 3 different standards to really help tease out the implications of their decision. The government has come in as an amicus supporting the plaintiffs, and the chamber, among others, have come in as amicus supporting Facebook. The government's brief argues that whether each and every particular risk factor statement carries a misleading implication about past events depends on the facts and context. As the chamber argues, this kind of test results in significant over-disclosure as companies seek to avoid unending litigation risk from every statement in already voluminous risk factor disclosures, which would be contrary to the SEC's stated purpose of Item 105, which is to provide a, quote, organized and concise risk factor disclosure, and to discourage the disclosure of information that is not material. Attempting to argue that this is a dramatic overselling of the harms of the Ninth Circuit's rule, the government cites the independent requirement that the misrepresentation or omission is material, and argues that the determination whether reasonable investors would read a particular risk statement to imply the non-occurrence of particular past events depends on context. But what context would be more relevant than the fact that the breach was publicly disclosed and had no impact on the company's stock price? The investing public had already determined that the breach was not material. So there are a lot of different things for the court to unwind here. And so turn things back to you, Sarah.
Thanks so much, Tyler. We look forward to seeing how the court resolves this circuit split. Next, we will hear from Colin White.
Thanks so much, and thank you to the Federalist Society for hosting me. And as with Tyler, just a disclosure from the beginning, or disclaimer rather, that the views I'm about to express are mine and not those of my firm or any of its clients. I'm here to discuss a case called Monsalvo Velasquez versus Garland. It has to do with what is commonly called IRIRA, or the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. Under that statute, an immigration judge can allow a non-citizen who is ordering to be removed from the United States to voluntarily depart at the end of the removal proceedings under certain conditions. Generally speaking, things like that they're a person of good moral character and can leave at their own expense. In the statute, Congress also said that that voluntary departure period shall not be valid for a period exceeding 60 days. And there are some stiff penalties for overstaying your welcome. These include monetary penalties and a 10-year bar on most forms of lawful status. But there's an exception, and that is that you can file a motion to reopen if you can point to newly discovered evidence or a change in circumstances during the hearing. And as a practical matter, given some BIA regulations that aren't worth getting into at the moment, filing that motion to reopen means that the penalties for overstaying the voluntary departure period don't attach. The question presented here is, what happens when that 60th day is a Saturday, a Sunday, or a holiday? In 2012, the Ninth Circuit said that it runs on the next business day. The 10th Circuit in this case disagreed. The case is fully briefed and it'll be argued first on November 12th. Our firm filed an amicus brief for 43 former immigration judges for the petitioner. The government's position is facially straightforward. 60 means 60. It does not mean 62. The statute, the government also emphasizes, regulates private conduct, and there's no reason that one can't fly out of the country or otherwise leave on a weekend or holiday. So in the government's telling, there's no reason to extend that deadline. It also has a jurisdictional argument that it lost in the 10th Circuit and that the court didn't bite at the cert stage, so I won't dwell on that here. The petitioner disagrees, and the fundamental thrust of that disagreement is this notion that the statute incorporates the familiar rule that deadlines running on weekends and holidays actually run on the next business day. He points to several different arguments. The first one is about the common law background, and there's quite a lot of back and forth in the opening and response brief about the state of the law in England at common law. But it seems more likely that the court's going to focus on issues internal to immigration law and the meaning of the phrase by 1996 when it was actually adopted. The second cluster of arguments that the petitioner relies on have to do with the regulatory background and some BIA decisions that had incorporated this particular rule, this background principle, into BIA practice and into its own regulation. There's no real disagreement between the government and the petitioner about whether Congress legislated against that background in 1996. there is some more weedsy disagreement about whether that background actually speaks to this particular provision. And the third cluster of arguments the petitioner relies on, and ones that the amici for the petitioner spent a bit more time on, have to do with how the voluntary departure deadline relates to the filing of a motion to reopen. It's pretty easy to imagine some harsh and arbitrary consequences that follow from the government's position. If you imagine somebody who is planning to leave the nation on a Sunday, then on Saturday gets a call from the cartel saying, "We're waiting for you when you get home." That person then is put to the choice between either getting on the plane and potentially risking their life, or on the other hand, suffering these consequences that follow from that overstaying of their welcome under the voluntary departure provision. The government effectively concedes that these are possible, but thinks they're unlikely. Uh, there were three different amicus briefs filed for the petitioner, none for the government. The thrust of the amicus briefs supporting the petitioner go to the understanding of the bench and bar of this provision. So the judge, even in this very case, calculated the petitioner's departure period using this background principle. In other words, said that it would run on the first day following the lapsing of the 60-day period over the weekend. There also are a number of practical points where the government's position arguably creates significant problems. There's quite a lot of guidance from the agency about various other deadlines that run in this context, where concern would be you're going to carve out a very specific exception in this one context where most people who are proceeding are proceeding per se, and they have limited English, and the government's approach then makes this complicated decision. It shortens the period in which certain people effectively have to decide whether to leave the nation or file this motion to reopen, based really on the happenstance of what day of the week one's order was actually issued. In terms of implications, this isn't the headline grabber of the term. It's probably important mostly within the immigration context, but I'll put one asterisk on that. The court will have to deal with the fact that deadlines like this one are going to appear in lots and lots of other statutes. And that's one reason why, again, just speaking for me, I think the court's likely to tailor its decision to this specific context without leaning quite as heavily on the deep common law history archaeology that comes up in both of the opening and response briefs. And really the reply makes clear that what this turns on in the end is what the meaning of the text was in 1996. So with that, I'm happy to yield the floor.
Thanks so much, Colin. This is just another reminder to the audience to submit your questions to the panelists, and we'll address them at the end. Closing us out for today will be Bob Peck.
Thank you, Sarah, and thank you to the Federalist Society for inviting me to participate. I'm here to talk about the NVIDIA case, which concerns the Private Securities Litigation Reform Act. It was enacted in 1995 under a perception that there were too many cases, which, as the managers put it, had only a faint hope that discovery would supply the basis for a cause of action. So bare bones types of complaints that sought to basically make their case through discovery were the ones that the PSLRA sought to try to make easy for dismissal. Now, there are two aspects to this. There's a scienter requirement under the PSLRA that you have to plead, and there's also the claim of falsity. This is a securities action in which the question is whether or not there were abuses, if there was deception, misrepresentation, or fraud in connection with the purchase or sale of a security. And so while the PSLRA tried to tighten pre-Iqbal Twombly the type of pleading that might occur, it also recognized that private securities litigation was an essential and as the court called it in Tellabs in 2007, an indispensable part of protecting securities law. And so therefore there was a great dependence on this private litigation. So this case involves NVIDIA, which in the past week became the world's most valuable company, surpassing Apple with a value that's in excess of $3.5 trillion. And what does NVIDIA make? Well, it makes these graphic processing units that are in all computers and are particularly valued by gamers. These units basically make it more efficient for the computer to go through the various kinds of computational steps that they undertake in order to produce images, computations, movement, and everything else that we enjoy in computers. So what they discovered was, of course, the gamer customers were particularly valued to them, but also they discovered that cryptocurrency required the same kind of strength in computations. And so therefore, there was a new market when cryptocurrency miners were looking for the kind of speed and strength in their computations that these processors could provide. So they realized that as a result of the interest, there was a surge in sales. It also caused the processing units to become more expensive as supply and demand also were affected, and decided that they were uncertain whether the cryptocurrency boom would continue to support this. And so they decided to create a separate, very similar kind of processing unit that was oriented towards cryptocurrency, and that way they might be able to track how much goes to cryptocurrency and how much to essentially the gaming population. What happened was that a lot of the cryptocurrency miners liked to use the traditional gamer GeForce units that they had, and so therefore it was very difficult for them to track it. At the same time, they were assuring people that they were not dependent on cryptocurrency, and therefore this was not really going to affect the value of the company. They realized it was an uncertain market, and by reporting it separately, they thought that they would be able to do this, but they really weren't being able to separate how much were essentially being used for gamers and how many were used by cryptocurrency miners. So the result was continued strong sales for a while, but then they fell. They've rebounded now as their current value reflects. But the accusation that was brought by these investors was that NVIDIA concealed the extent to which their gaming products were being dependent on crypto. And that fact was inconsistent with the public statements that they had issued. So this was the basis for this lawsuit. Now, NVIDIA looks at this complaint. It's an 80-page complaint. It's supported by different kinds of evidence, whistleblowers who are former employees about the kind of data that the executives consistently looked at, the types of reports that are always generated, and that sort of thing. Several government investigations, including one by the government of Canada, and as well as an expert report that looked at the data, what was appropriate to look at and consider, and what that would mean. So NVIDIA comes before the Supreme Court after losing in the Ninth Circuit, and basically says there are two things that are required here. Because the PSLRA requires pleading with particularity, that means that the documents that you are essentially describing must be really revealed. You must be very specific about those documents and what they actually say, and whether or not these executives that you say misrepresented really read those and saw it, because the most direct evidence of scienter is showing that the documents that contradict what the executives say is what they have actually read. And so basically they're putting them to a level of proof that seems to be inconsistent with notice pleading, which still applies even when you have to plead with particularity. And so they're questioning that, and they're questioning whether or not evidence from an expert is appropriate in these kinds of complaints. And so that's the second question that they're really presenting is the expert evidence essentially just opinion and therefore inappropriate to a complaint, Or, as we know from the evidentiary rules, that expert reports often contain facts. They also contain explanations of the significance of those facts. And so this 80-page complaint that was filed in this case, they're saying basically still it's not specific enough and too speculative. And so those are the questions before the court. Now, one of the things, of course, is that we know from decades of precedent that a complaint is not supposed to be proof of the case. And this seems to me move very much in the direction of requiring the complaint essentially provide the proof. We still depend upon compulsory discovery, and for those internal documents that NVIDIA says must have been reviewed and described in rather specific detail in the complaint, you know that you don't have access to those without compulsory process. And so that's part of the defense here that the Ninth Circuit got it right, because the original plaintiffs say that they could not have gotten that. It would require them to essentially recruit whistleblowers of current employees who would either secretly steal the documents, which would be a crime, or otherwise be subject to the fact that they would jeopardize their entire careers by doing something like that. And at the same time, the expert evidence, they say, is entirely appropriate to connect the dots and to show why certain data that is publicly available leads to the kinds of conclusions that the plaintiffs have put forward. Now, in Tellabs, the court dealt with the scienter part of the PLSOR. And what they said is that, because the statute talks about if you have a belief that the scienter requirement is there, you have to basically show what is the basis that there is a strong inference that the executives who you're accusing of essentially falsity have shown what they have believed to be correct. So strong inference, that does not mean that you have to have proof. And indeed, to get to a strong inference, especially when we give reasonable inferences in complaints, circumstantial evidence is often enough. But NVIDIA argues before the Supreme Court that circumstantial evidence should not be enough. And so what we have here is basically a lot of going back and forth about whether this evidence that was described or the allegations that were made in this complaint are sufficient to meet the PSLRA. Now, from a viewpoint of someone who does not litigate in this area, it does seem as if there was significant information in this complaint and that this might not have been the best vehicle to present these kinds of issues before the court. The question then becomes, does the court look at this in terms of saying, well, we're going to draw some categorical lines here that have to be met? That seems to be something the court is often reluctant to do. And so I'm not really expecting that to be the case. And if I were to guess at what the court might do, it might be something that doesn't satisfy either side and leaves the matter for further litigation down the line.
Thank you, Bob. And thank all of you for your insightful comments on this fascinating docket that we have coming up. Now I'm just going to take a moment to run through the remaining cases that are at the court this November. On November 5th, the court will hear Advocate Christ Medical Center versus Becerra on appeal from the DC Circuit. This case involves the calculation of Medicare reimbursements to hospitals under the disproportionate share hospital adjustment. This adjustment provides additional compensation to hospitals that serve a high percentage of low-income patients. The adjustment is based in part on the percentage of a hospital's Medicare patients who are also entitled to supplemental security income benefits. Under the current scheme, the Department of Health and Human Services only considers patients who qualify for monthly payments during their hospital stay to count as those entitled to supplementary security income benefits. 200 hospitals challenged this interpretation. They argued that all patients who are enrolled in the SSI program should be included, even if they don't receive a payment that month. The district court, however, granted summary judgment to HHS, and the DC Circuit affirmed. So the question presented in this case is, whether the phrase entitled to benefits, which is used twice in the same sentence of the Medicare Act, means the same thing for Medicare Part A and the supplemental Social Security benefits, such that it includes all who meet basic program eligibility criteria, whether or not benefits are actually received. And finally, on November 11th, the court will hear Delegati versus United States on appeal from the Second Circuit. This is a criminal case that concerns 18 U.S.C. Section 924, which establishes a mandatory minimum sentence for carrying a firearm during a crime of violence. The appellant is Salvatore Delegati. He's also known as Fat Sal and is an associate of the Genovese crime family in New York City. He was convicted of attempted murder in aid of racketeering and possession of a firearm in furtherance of a crime of violence and sentenced to 25 years in prison. On appeal, Delegati argued that his firearms conviction, which tacked on an additional 5 years to his sentence, he argued that this conviction should be vacated because the attempted murder charge was committed through inaction and therefore was not a, quote, crime of violence. The Second Circuit affirmed the lower court's judgment and concluded that attempted murder does qualify as a crime of violence because it necessarily involves the attempted use of physical force. The question presented in this case is whether a crime that requires proof of bodily injury or death, but can be committed by failing to take action, has as an element the use, attempted use, or threatened use of physical force. And that concludes the cases that the court will hear in November. So now we will turn to the question and answer portion of our program. I would just remind everyone to put your questions in the Q&A bar at the bottom of the screen. And we first have a question from Anonymous. This question is for Karen. The person asks, last month in United States, XREL Zafirov versus Florida Medical Associates LLC, a judge on the Middle District of Florida held the False Claims Act's Keaton provision violated the appointment clause. Will this case affect Wisconsin Bell at all?
Sorry, I forgot to mute it. I don't know that this particular case will affect it. I do think that it is, really part of a trend we're seeing. As I referenced in my remarks, the Center for Constitutional Responsibility, which I actually run, filed a brief in this Wisconsin Bell case, making the case that we think there's some constitutional issues with the False Claims Act. We also did note that we didn't think this was the right case to decide that question, but that the court should take that up. Really, since Polanski, which I also referenced, which was 2 terms ago, and Justice Thomas's dissent in that case, in which he also, or no, not dissent, concurrence. Or no, it was his dissent, sorry. Anyway, which he questioned the constitutionality of the False Claims Act. You're seeing more and more people raise this when they're defending against, allegations that they're in violation of the False Claims Act. To date, Mazant, who was the judge in that Florida case, is the only one that I know of that has said that it's unconstitutional in the appointment of these relators. But I do think that you're going to continue to see these arguments come. And, again, Thomas made, I thought, an invitation for more of this. So I do think this will be something that we'll continue to see come up, through the appellate courts and then ultimately, hopefully, the Supreme Court.
If I can jump in, the court also has pending before it an appointments clause case out of the Fifth Circuit right now, Braidwood Management. And that case, of course, gives the court, because it's filed, the petitions filed by the United States, it gives the court a very strong opportunity to talk about the appointments clause and how it applies. In many ways, I read this case, Wisconsin Bell, as sort of the opposite side of the coin, because it really talks about whether or not these are voluntary private organizations or not. And that, of course, is part of what's at issue in the Braidwood case, because that involves the U.S. Preventive Services Task Force, which are private individuals appointed and subject to firing by the HHS secretary, but they're supposed to be acting independently and on the basis of scientific evidence and coming up with their standards.
Thank you, Robert, and thank you, Karen. Our next question is for Colin. Regarding those in the hypothetical who, quote, overstay their welcome, as you described, what happens to them under current practice on the 61st day? In other words, if they haven't departed, are they required to surrender or become charges of the government instead of being sent back? Or will their status as having good moral character and the ability to pay put them in a quasi-limbo state in the US?
It's a good question, and it goes to the regulations that I alluded to at the start. The punchline is that when the IJ issues an order allowing for voluntary departure, they'll also issue an alternative order of removal at the same time. And if the petitioner files a motion to reopen, that voluntary departure order is treated as terminated, and then the alternative order of removal kicks in. And the real gravity here has to do with getting out from underneath the monetary penalties and potentially a 10-year bar on going back into the country. So that's the way the mechanism works. If you're interested in that, it's certainly covered in the briefing, a bit of the petitioner's brief, and I think in the brief for the for IILS. So another one of the amicus briefs.
Great, thanks, Colin. We actually have another question for you. Do you think that the court will take into account the immigration rule of lenity? Has the court applied this rule to the voluntary removal statute before?
So I don't know the answer to the second question. On the first one, that's something that absolutely has been pressed in the briefing. Certainly, I believe our clients did, and it's something that's heavily emphasized in some of the others. So I do think the court's likely to take that into account.
Great, thank you. We have a question for Tyler. Do you see any way that the court could clarify or distinguish its Encino case and yet still find that the clear and convincing evidence standard will apply or should apply?
I mean, I think the employer relies on Encino quite heavily to support their argument that the lower standard of proof should apply. So I'm not sure how exactly the court would go about doing that to distinguish Encino and then go to the higher standard.
Mm-hmm. Thank you. We have a question for Bob. Courts don't generally qualify experts at the pleading stage. So how can an expert opinion form the basis of an allegation of fraud?
Well, because of course it's an allegation. This is not evidence. The rules of evidence require us to go through the steps that we now know of from Daubert. But as an allegation, you take the allegations as true as pleaded, and so therefore it's appropriate to allow an expert to say that on the basis of their experience, they have understood that these are the ways these reports are done, these are the way that companies look at them, and this is the kinds of conclusions that might come. Now, of course, that will be subject to rebuttal at an evidentiary stage, and possibly also, they may not qualify as experts, but at this stage, we do not close the door to them.
Wonderful. Thanks, Bob. We have another question for Karen. Do you think that the Fifth Circuit case, Shupe, has lost its persuasive value since it was decided before the definition of claim under the FCA changed?
I don't know that I could really speak to that. I guess I would just say more broadly that I do think we're putting the constitutional concerns aside with the False Claims Act. I think that the Supreme Court is seeing the abuses of this act more and more. I mean, Polanski was a great example of that, because that was where the relator wanted to continue to press the claim when the government wanted to dismiss it. And even Kagan, who I think wrote the opinion in that case, said, no, the government gets to control these. And so the reason I say that is, or reference that, is because I just think, with this case, this Wisconsin Bell, I think there's a strong argument that if the government's position prevails here and Mr. Heath, the relator's position prevails, we're opening up even more companies and more liability. As I mentioned, Fannie Mae, Freddie Mac, any of these other creatures like the Universal Services Administration Company that are like products of the government to this act is just going to make it, even more claims. And I think my take is the Supreme Court doesn't want, they're not looking for more False Claims Act cases at their court. But maybe I'm wrong. We'll see.
Thank you, Karen. If we have no other questions, I would like to thank everyone so much for their time today. We are very appreciative of our panelists. We know you all have very busy schedules, and we appreciate you taking the time to share with us your perspective and your insights on these important issues. I'll turn it back over to Nate now.
Thanks, Sarah. Appreciate it very much. I'll echo your gratitude. Thank you to the panel for an excellent preview. Great job all around. We will look forward to seeing how these cases play out next month. For the audience, your feedback would be appreciated at info@fedsoc.org. We look forward to seeing everyone soon at the National Lawyers Convention. Until then, we are adjourned.